All right, we are back on the state of Georgia versus Travis McMichael, Gregory McMichael, and William R. Bryan. With the jury having reached a verdict, the court indicated that it would schedule sentencing. The sentencing was noticed for today. Is the state ready to proceed?
Yes, Your Honor, the state is ready to proceed.
Is Travis McMichael ready to proceed?
Yes, Your Honor, we're ready.
Greg McMichael.
Yes, Your Honor.
And Mr. Bryan.
Yes, Your Honor.
Okay. Any preliminary matters from the state?
No preliminary matters from the state, Your Honor.
Any preliminary matters from Travis McMichael?
No, Your Honor.
Greg McMichael.
No, Your Honor.
And Mr. Bryan.
Yes, Your Honor. We filed 3 motions this morning. I have a 4th motion to make orally. I'm not going to belabor them at any great length, but I did want to have them on file for the record. We filed this morning a motion to bar imposition of sentence of life without parole as to defendant Bryan for felony murder. That is basically, we're arguing for an extension of the decision of the U.S. Supreme Court in Edmond v. Florida, which held that individuals who are convicted of felony murder without killing, attempting to kill, or intending to kill are not eligible for the death penalty. We're pursuing that both under the 8th Amendment to the United States Constitution and Article 1, Section 1, Paragraph 17 of the Constitution of the State of Georgia. We're asking the court to extend that reasoning one step further, reflecting evolving standards of decency, and hold that the imposition of a sentence of life without parole for felony murder would likewise be unconstitutionally cruel under our constitutions, absent evidence that defendant Bryan killed, attempted to kill, or intended to kill Ahmaud Arbery. We don't believe any of those facts are in dispute in this case. That's our first motion.
Anything from the state?
Yes, Your Honor. The reason felony murder and different from malice murder is because of the lack of specific intent to commit the murder. As we all know, when a co-defendant like 2 men go into a convenience store and they attack the convenience store clerk, and the clerk, defending himself, shoots and kills one of the armed robbers. The first armed robber is responsible for the death of his friend and co-defendant under felony murder, because while there was no intent for one armed robber to kill the other armed robber, it's a matter of responsibility under felony murder, not a matter of intent to kill. And in this particular case, Mr. Bryan is eligible for this court to impose a sentence of life without the possibility of parole. There is nothing preventing this court from doing that on a felony murder charge, because felony murder, once again, is about responsibility, not about intent to kill. Thank you.
All right. Mr. Goff.
Your Honor, with all due respect to Ms. Kowski, I don't believe that response addressed the issue. The issue is for an individual such as Mr. Bryan, who did not kill, did not attempt to kill, and did not intend to kill, whether or not the 8th Amendment allows the imposition of a sentence of life without parole is not a question of the Georgia sentencing scheme or statutes. It's a question of federal constitutional law. Clearly, under those circumstances, the death penalty, imposition of the death penalty, is cruel and unusual. We are contending, since Edmond v. Florida in 1982, that standards and our sense of decency as a society have evolved to the point where the 8th Amendment does not allow the imposition of a sentence of life without parole for felony murder, absent killing, an attempt to kill, or intent to kill. And I don't think the state contests that those are not the facts of this case. I think the state is relying on the fact that the United States Supreme Court hasn't addressed this issue yet, at least not to my knowledge. We're preserving the issue for appeal.
All right, the court received the motion to bar imposition of sentence of life without the possibility of parole as defendant Bryan for felony murder this morning. It looks like it was filed at 8:18. I have reviewed the motion. It cites the one case that was just referenced by Mr. Goff, and having considered the arguments of counsel, the court denies the motion. Mr. Goff.
Thank you, Your Honor. Our second motion is a motion to declare unconstitutional mandatory life sentence for felony murder for a discrete class of offenders, and in the alternative, motion to bar imposition of life sentence as to defendant Bryan for felony murder. The previous motion addressed whether or not Mr. Bryan was eligible under the Eighth Amendment for a sentence of life without parole. This motion challenges whether Mr. Bryan can be sentenced to a mandatory life sentence for felony murder, both as a class of individuals who have not killed, intended to kill, or attempted to kill, and also as to Mr. Bryan individually. And we contend that this is essentially, the first part of it is taking the Edmund case that has already been discussed this morning, not one step, but two steps, to strike down mandatory felony murder for people that convicted of felony murder that fall within that class of individuals that have not killed, attempted to kill, or intended to kill. This is an issue which has tremendous import in the state of Georgia and around the country, in that there are hundreds in Georgia and probably thousands of individuals around the country who are serving life sentences, have been in prison for many, many years, who drove the car that was used to escape from the armed robbery, or provided the key to break into the house not knowing that it was occupied. There's all kinds of people out there across the country serving life sentences right now who never killed, attempted to kill, or intended to kill, but have been subjected to mandatory life imprisonment. I would venture to say the majority of those individuals tend to be African American, but I haven't studied it in depth in a while. But that doesn't matter. It doesn't matter whether you're white, black, or Martian. It's still wrong for the legislature to require this court, to compel this court as a matter of law to impose a mandatory life sentence on an individual who hasn't killed, attempted to kill, or intended to kill. And again, this is an issue that would have significant impact if it were granted, but we are certainly preserving that issue. Secondly, with respect to Mr. Bryan individually, we believe that he is not eligible for imposition of a mandatory life sentence pursuant to the Eighth Amendment, based on the totality of the circumstances surrounding the offense, his criminal history and other circumstances, which we'll get into during the sentencing hearing, and that the imposition of a life sentence to Mr. Bryan would be unconstitutionally cruel and disproportionate. And we cite the relevant Supreme Court authorities as to that issue.
Thank you, Judge. Your Honor, the legislature has spoken not only with 1651, which imposes a mandatory life sentence for felony murder, but also with party to a crime and conspiracy. All of those laws are on the books for a very important reason, which is responsibility for your actions. And at this point, the state is asking that this court not fly in the face of the legislature or the statutes that are on the books, especially 1651, based on this particular argument that somehow Mr. Bryan is special and outside the imposition of the law. Thank you.
Any further word on that motion?
On behalf of Greg McMichael, we'd like to join that motion, but without any further argument.
It doesn't apply to us, really.
Your Honor, I don't have to object. I'm arguing, I guess. But the idea that Mr. Bryan is asking for special treatment here is just wrong and contrary to the argument actually made. Our position is that no one in America convicted of felony murder who didn't kill or attempt to kill or intend to kill should be subjected to a mandatory life sentence. That doesn't mean that a court couldn't impose a mandatory life sentence. It means that the court should constitutionally have the discretion to impose the sentence that is appropriate, and for the legislature to dictate that these individuals, such as Mr. Bryan, the court cannot consider a sentence of less than life imprisonment is cruel and unusual, and this practice needs to stop. It's gone on since before I was born, before Your Honor was born. It was wrong then, it's wrong now, and sometime, somewhere, it has to stop. Secondly, as to Mr. Bryan individually, again, it's not suggesting that Mr. Bryan is special. It's suggesting that anyone in Mr. Bryan's circumstances. Under the facts of this case, anyone besides Mr. Bryan with the same criminal history, with the same background, with the same circumstances, that imposition of a mandatory life sentence would likewise be disproportionate as to them. So this is not a request for special treatment. It is a request for individualized sentencing consistent with the Eighth Amendment.
All right. Again, the motion is filed this morning. I did have an opportunity to review the motion. Having heard the arguments of counsel, the court denies the motion. Mr. Goff.
Our third and last formal written motion is a motion to vacate illegal felony murder convictions based on double jeopardy. And I don't want to be accused of plagiarizing. An inmate apparently from the Michigan criminal prison system, Mr. Sires, was kind enough to draft a motion for me to file, and even went out and found Georgia case law. Your Honor, I have to confess it doesn't quite reconcile with my memory of all of the Georgia case law, but the argument's pretty good. Mr. Bryan was acquitted of count 2, felony murder. There is only one felony murder statute. And therefore, once you've been acquitted of felony murder in count 2, double jeopardy bars conviction under counts 3, 4, and 5. The argument being that they're all different ways to commit the same offense. And we believe that under the authorities, which are not just state authorities, they're federal authorities, including Ahmaud v. U.S., 437 U.S. 54, that the court should find that double jeopardy bars imposition of sentence under counts 3, 4, and 5. Independent of that, we also have an issue with respect to the jury returned a verdict of not guilty as to the lesser offenses on count 7, and therefore the verdict on count 7 is repugnant with the verdict of the jury as to the lesser offenses. I would note, I don't recall the court asking the jury to address the lesser offenses unless and until Mr. Bryan was found not guilty on the indicted offense of count 7. But nevertheless, the jury did return verdicts of not guilty. The state did not object to the return of those verdicts at the time. And those not guilty verdicts on those 3 lesser offenses are repugnant to the conviction on count 7. And therefore, count 7 should be set aside for that reason. And that is my motion.
From the state.
Thank you, Judge. Your Honor, it has been the law in the state of Georgia and commented and gone over by the Supreme Court of Georgia, especially as recently as 2015 in Duggar versus the state, D-U-G-G-E-R versus the state, 297 Georgia 120. And similar circumstances where a defendant was found not guilty of the malice murder charge, but guilty of the felony murder charge, and he claimed double jeopardy because only one person was dead and they came back not guilty on the malice. And in this particular case, Duggar, they said, no, that's not how this works. Appellant faced a single prosecution and he received a single punishment for murdering the victim. That's the quote from this. His double jeopardy rights were therefore not violated. In addition, he wanted to argue that these were inconsistent verdicts. Once again, the court held that that is not the case. There was no inconsistency between the verdicts of guilty on felony murder and not guilty on malice murder. Now, of course, in this case for Mr. Bryan, he's claiming, well, there was a series of felony murders. Well, the felony murders are predicated on certain underlying acts. And in this case, the jury did find him not guilty of aggravated assault with a shotgun and also not guilty of felony murder based on that aggravated assault with the shotgun. So therefore, their verdict was consistent in that manner, but they did find him guilty of aggravated assault with the pickup truck, false imprisonment, and criminal attempt at false imprisonment, and the felony murder associated with that. The state is going to, of course, argue that 2 of those felony murders will be vacated by operation of law and that Mr. Bryan will only be sentenced to 1 of the felony murder counts. And so therefore, based on Duggar as well as numerous other cases, and I believe Duggar was most recently cited in 2020 by the Strong case by the Georgia Supreme Court, that there is no sound legal basis in the state of Georgia for a double jeopardy claim, as well as numeration 22 on page 4 of Defendant Bryan's motion. Finding someone not guilty of a lesser charge doesn't necessarily mean they're not guilty of a more egregious charge. So the fact that they came back not guilty on those lesser charges versus the more heavy charge does not all of a sudden mean that it's a repugnant and or inconsistent verdict. We ask that you deny the motion. Thank you.
Your Honor, as Ms. Donikoski was so kind to point out, Duggar is readily distinguished. Obviously, malice murder is one crime, felony murder is another. Ms. Donikoski is confusing the merger concept with the double jeopardy issue. In this case, these are all felony murder counts, but they're all the same crime. So that is what distinguishes the Duggar case. And furthermore, with respect to the lesser offenses, Your Honor, the jury's verdict on the 3 lesser offenses of not guilty indicates that the jury concluded that an element of the offense, the greater offense, was missing. The verdicts are repugnant. I would submit they're repugnant as a matter of law, and that therefore the court must vacate count 7 as to Mr. Bryan. And that doesn't mean that there won't be 2 other felony murder counts left. It may be an academic discussion, but nevertheless, we're asking the court to vacate the conviction under count 7 as repugnant with the 3 misdemeanor counts and impose sentence on the misdemeanor count only.
Again, as previously indicated, the court received the motion this morning. I did take a look through the motion. We've taken a look at Duggar. The case is cited by the state, and the court denies the motion. I understand you've got one oral motion?
Yes, Your Honor. And I appreciate the court's patience. Your Honor, we are making an additional constitutional challenges to Georgia's sentencing scheme with respect to the imposition of a sentence of life without the possibility of parole. And again, as I think prosecutors suggested many years ago, a lot of the sentencing jurisprudence and criminal law jurisprudence began in death penalty cases with the theory that death is different. Well, I think the evolving case law over the last several decades has demonstrated that death is really not so very different after all. We would assert 8th and 5th Amendment challenges to Georgia's sentencing scheme, which rightly gives judges broad discretion in determining sentences, but with respect to life without parole, that discretion is effectively unguided, as opposed to the sentencing scheme in a death penalty case for determining the imposition of the death penalty. Besides being cruel, the sentencing scheme also violates due process in that the statutes fail to provide sufficient guidance to the trial court. And therefore, Georgia's sentencing scheme is hopelessly ambiguous as well as arbitrary and capricious. Moreover, without any required findings of fact or conclusions of law, there is nothing for an appellate court to review to determine whether a sentence of life without parole has been lawfully imposed. Furthermore, we assert a 6th Amendment challenge, which I would call an Apprendi challenge, although it's not actually the authority, that any facts that increase a mandatory minimum sentence must be set, which in this case would be life without parole as opposed to a life sentence, that any fact that increases a mandatory minimum sentence must be submitted to a jury and found true beyond a reasonable doubt. And I cite Olen v. U.S., ALLEYNE, 133 S. Court 2151, 2013. Blakely v. Washington, BLAKELY v. Washington, 542 U.S. 296, 2004. Your Honor, the jury acquitted as to counts 2 and 6. With count 7, it is impossible to determine what facts the jury found in this case because the state elected to pack so much into count 7. You've got parties to the crime, you've got principals to the crime, you've got the McMichaels pickup truck, you've got Mr. Bryan's pickup truck, and you've got whether it's an intent to injure or whether it's placing Mr. Arbery in reasonable apprehension of receiving an injury, there's so many different theories that the jury could have returned a verdict on that there's no way to draw any findings, meaningful findings of fact for sentencing purposes from the verdict that the jury rendered. And therefore, under these circumstances, there's nothing here for which the court could find a jury-found basis for imposing the sentence that the state is seeking in this case. Thank you.
Judge, on behalf of Mr. McMichael, we would join the motion.
On behalf of Greg McMichael, we'd like to join that motion.
Noted for the record. From the state.
Of course, the state's at a bit of a disadvantage, just having heard the motion, as is the court. However, the state's position at this point in time is this is a legislature issue. The legislature has passed 1651, and it is a mandatory life sentence. The court does have discretion between life or life without the possibility of parole. The complaint here, it sounds like, is, well, there's an Eighth Amendment violation, a Fifth Amendment violation, a Sixth Amendment violation because there's no guidance to the court. However, as this court is aware, the Supreme Court of Georgia has given Superior Court judges great deference because this court has heard the evidence. This court has seen the demeanor of the defendants, especially in this particular case, the demeanor of Travis McMichael as he testified. This court has seen the evidence from the witnesses on the stand and the body cam video of what took place. So in this case, the court is going to be given and has received the evidence in this case for its review to inform it and its discretion as to whether to impose a life sentence or a life sentence without the possibility of parole. I believe the next step in this process, of course, is going to be the state presenting victim impact and then argument. The defense will present its argument, all of which also informs this court and allows it to use its broad discretion and judgment as to whether to impose a life sentence or a life sentence without the possibility of parole. So we ask that you deny this motion. Thank you, Judge.
Final word.
Your Honor, with all due respect to Mr. Dunkowski, this is not a legislative issue. The Constitution is not up for discussion or negotiation. The Constitution is what it is. The Fifth, Sixth, and Eighth Amendments to the United States Constitution are the federal provisions at play here, in addition to the parallel provisions of our Georgia state Constitution. Legislators are politicians. They have to run for election, and they do what they think they need to do. And the job of the judiciary, as the independent third branch of government, is to put a check on that action when it violates our state and federal constitutions. So simply saying that it is a legislative issue, it doesn't address the question. And ultimately, it is for our courts to defend that Your Honor and the courts above you are the ultimate guardians of our state and federal constitutions and of the individual rights of individuals. And to simply say, or maybe that wasn't the suggestion, but one could interpret it that way, that the court should simply defer to the legislature as to what the Constitution means, to the extent that was their argument, is repugnant to our entire system of criminal justice. I'd ask the court to grant the motion.
All right. I didn't hear the argument quite that way, where the court has to defer to the legislature. There is a structure in place with regard to sentencing, and this court intends to adhere to that structure as established through Georgia case law. On that basis, the motion is denied. I understand those are all preliminary matters, and before the court, is the state ready to proceed with, and the way we're going to do it, as I understand it, is the state is going to present any evidence it has in aggravation as well as a opening argument. The defense is then going to have an opportunity each individually to present any evidence in mitigation if they wish to do so, and make argument, with the state then having the rebuttal. That's how I understand we're going to proceed.
Thank you, Judge. Your Honor, for the record, today is Friday, January 7th, 2022. The jury returned its verdict on November 24th, 2021. That verdict was that Travis McMichael was found guilty on all 9 counts in the indictment. Greg McMichael was found not guilty of count 1, which is malice murder, but guilty on the other counts 2 through 9 in the indictment. Mr. Bryan was found guilty only as to counts 3, 4, and 5, all felony murder counts, and the underlying felonies corresponding to those felony murder counts, which were counts 7, 8, and 9. The court asked all of us to look into, with regard to Travis McMichael, the issue of potential merger as to the malice murder charge. The state has reviewed its own indictment and notes that it charged Travis McMichael, who was found guilty of count 1, malice murder, a human being did unlawfully, with malice aforethought, cause the death of Ahmaud Arbery, a human being, by unlawfully chasing him through the public roadways of the Satilla Shores neighborhood in pickup trucks and shooting him with a shotgun, contrary to the laws of said state, the good order, peace, and dignity thereof. As the state notes, this encompasses 2 different actions. Unlawfully chasing him through the public roadways of Satilla Shores, which describes the actions they did in the pickup trucks, and then shooting him with the shotgun. As the court will recall, defense filed a demurrer to count 1, saying this was surplusage and should be removed. The state's argument was that the state was not going to argue it was an either-or situation, and that is not going to be the state's argument here. The state's argument here is that factually, the state believes that count 8, false imprisonment, factually has been eaten up by the way the state charged count 1 in this indictment. In other words, count 8 and count 6 would merge into count 1 for Travis McMichael on the malice murder charge because of unlawfully chasing him, meaning Mr. Arbery, through the public roadways of the Satilla Shores neighborhood in pickup trucks. The reason we believe that that factually would merge is because count 8 is actually the false imprisonment charge. And count 8 does say, said accused did chase Mr. Arbery with a Ford F1 pickup truck and a Chevy Silverado pickup truck through the public roadways of the Satilla Shores neighborhood and did confine and detain Ahmaud Arbery. As the court is aware, the statute has nothing to do with chasing. That is descriptive language factually. The statute has to do with confining and detaining the victim. The fact that the state used up factually both the chasing in count 8 and the chasing in count 1 means both count 6 and 8 would then merge into count 1. I believe, and I could be wrong, but I will address this, that the defense may argue that count 7 and count 9 would also then merge into count 1 malice murder. However, the state's argument is that is not the case. The reason for that is count 7 is the aggravated assault with the pickup trucks. Did make an assault upon the person of Ahmaud Arbery with a Ford F-150 pickup truck and a Chevy Silverado pickup truck. An object, device, or instrument, when used offensively against a person, is likely to result in serious bodily injury. That, of course, factually can be a number of different things, and what the state did argue in closing argument was pulling up next to somebody, startling them, could put them in reasonable apprehension of receiving serious bodily injury. The state also argued in its closing argument that Travis McMichael, despite his testimony, actually used his pickup truck to pull in front of Mr. Arbery and cut him off, which caused Mr. Arbery on Burford to turn around and run away. So the fact that the jury found that they used their pickup trucks, objects which used defensively against a person are likely to result in serious bodily injury, did create an aggravated assault for Mr. Arbery, does not merge into count 1, which was unlawfully chasing him through the public roadways of Satilla Shores in pickup trucks. They are 2 separate and distinct things, especially when we have video evidence of the McMichaels pulling up next to Mr. Arbery then running away. That itself right there is an aggravated assault. He was obviously startled. He obviously was trying to get away from these men. They pulled up next to him. Reasonable apprehension of receiving serious bodily injury. With regard then to count 9 is criminal attempt to commit the felony of false imprisonment. As the court will recall, the defense also demurred to that particular charge in the indictment. That particular charge in the indictment did have an "and" in it, which, as the court knows, is an or, which the state explained in its closing argument to the jury. In this particular count 9, it did charge the defendants with did unlawfully chase Ahmaud Arbery through the public roadways of the Satilla Shores neighborhood in pickup trucks and did attempt to confine and detain Ahmaud Arbery without legal authority on Burford Drive using a Ford F-150 pickup truck. In this particular instance, the state did argue and did inform the court in the demurrer response that it was going to argue and or, because as we know, a criminal attempt is just a substantial step toward committing that particular felony. And as the court will note, count 8 took place on Holmes Drive, whereas count 9 was on Burford. So they don't have anything to do with each other. They're two separate incidents at two separate points in time based on the evidence in this case. So either one could be considered a substantial step, and because the and in between unlawfully chase and did attempt to confine and detain is really an or for the purposes of this, and once again, the state put that in its response to demurrer by the defendants, and the court denied the demurrer. That was filed by the defendants. The state also argued in closing argument that that was an or. They could find it that he was chased. They could also find that on Burford they did attempt to confine and detain him, especially with Mr. Bryan's actions of trying to run him off the roadway from his driveway and with Mr. McMichaels' actions of cutting him off at the end of Burford. So in this particular instance, especially with the criminal attempt, it does not merge into malice murder simply because of the words did unlawfully chase him through the public roadways contained in count 1. Therefore, when it comes to Mr. Travis McMichael, the state's position on sentencing and merger is this, that he is looking at a life sentence on count 1, malice murder, that counts 2, 3, 4, and 5, all felony murder, would be vacated by operation of law. Count 6, which is the aggravated assault with the shotgun charge, would factually merge into count 1. Count 7 would remain standing. And count 7 is a potential sentence of 1 to 20 years on the aggravated assault with the pickup trucks. Count 8, in the state's opinion, would factually merge then into count 1. False imprisonment, of course, is a 1 to 10 potential sentence. And count 9, criminal attempt, cuts that sentence in half. So count 9, criminal attempt to commit false imprisonment, is a potential of 1 to 5 years. Therefore, the minimum sentence that this court could impose on Travis McMichael would be life with the possibility of parole with 15 years, and that court could suspend, probate, run concurrent with that particular sentence. The maximum, and that is what the state is asking for in this case, is a life without the possibility of parole. The state did file its notice of its intent to seek life without the possibility of parole back in 2020 when this case was first indicted. So the state is seeking life without the possibility of parole as to count 1. Counts 2 through 5 are vacated by operation of law. Count 6 would merge into count 1, leaving then count 7 and 9, which would be 25 years. We are asking that that 25 years be a 25-year sentence, but to be run concurrent if the court chose to impose a life without the possibility of parole sentence. And that would be count 7 concurrent with count 1, 20 years to serve. Count 9 concurrent with count 1 consecutive to count 7, thus making it a total of 25 years running concurrent with the life without the possibility of parole sentence on count 1 for Travis McMichael. And that is what the state will be requesting and seeking. With regard to Greg McMichael, he was found not guilty on count 1, malice murder. He was then found guilty of counts 2, 3, 4, and 5, all felony murder. The state is seeking, therefore, a life without the possibility of parole sentence on count 2, which is felony murder based on count 6, which is the aggravated assault with the shotgun. Counts 3, 4, and 5 would be vacated by operation of law. Count 6 would merge into count 2, the felony murder. In this particular case, that felony murder only alleges did cause the death of Ahmaud Arbery based on the aggravated assault with a shotgun, so we do not have the same issue with language of chasing in count 2 of this indictment. This would, of course, leave count 7, count 8, and count 9 available for sentencing. Count 7 is aggravated assault with the pickup trucks. That's a potential 1 to 20-year sentence.